So May 8th, 2023, this case was set for discovery. It was called back on June 5th, 2023 for discovery. Then it was called back on August 3rd, 2023 for discovery. Then it was called back on October 5th, 2023 for discovery. My problem is everybody comes in here and wants a special setting for trial. I give you a special setting for trial, and then at the last minute, the week before trial, people are not ready. Court is calling 2019 CR 12495, State versus Tamar McIntyre. Can I have parties announced for the record for the state?
Jason Gehring, Your Honor.
For the defense?
John Hunter for Mr. McIntyre, Your Honor. I believe that
Where is he?
Mr. Goldstein is.
Yes, he is.
by
He's here.
Good morning, Your Honor.
Good morning. All right, this is scheduled for jury selection on Friday. Why are you all here? What motions do you have?
The state filed just a motion on limine, Your Honor, just for a few things. I don't know. It was filed this morning, so I don't know if defense has had an opportunity to view it.
I've not received service of it, Your Honor. Mr. Goldstein advised me just by telephone about 2 minutes ago that he saw that it had been filed, but I don't believe he's read it either.
All right, so
I was unable to open it, Your Honor. My apologies.
No problem. With regards to motions and limines, I do not know anything about this case. So as far as me ruling on any motion and limines, unless it's something that's specifically in case law where it's not allowed, then of course the court will make its ruling. But if it has to do with whether or not certain questions should be asked or whether or not certain evidence should be presented, y'all will need to approach prior to going into whatever subject matter you have with regards to motion and limines from the defense or from the state.
And Judge, it's not something associated with voir dire, it'd be associated with the actual case in chief and punishment. So it's not a question of hearing it before we pick a jury.
All right.
Your Honor, if I may, I'm particularly concerned about a recent disclosure that the state's key witness has given prior sworn testimony before a previous judge in this court regarding our client's participation in this case. And I believe I would like to make sure that we're able to supplement our motion for continuance with state versus.
Just 1 second. Let me finish addressing the state. Are there any other motions?
Not at this moment, no, Your Honor.
All right, defense, any motions?
Your Honor, we filed a motion for continuance back on January 24th, and I informally had advised the court of the fact that that was a concern. Let me update the court since then, because there will be need for us to supplement.
All right, and before everybody updates me on the supplemental as it relates to the motion for continuance, let me ask everybody a question. Did I not ask you all what date you all wanted for jury trial? I had given everybody continuances before. People wanted to go on vacation or trips with their family members. I let them go. I said, talk to the coordinator and choose a jury trial date. Is my memory faulty, or is that what I did?
Your Honor, let me, if I could give.
Well, no, we're gonna get to that. But did I do that?
Yes, Your Honor.
Did you all choose this date as your jury trial date?
Yes, sir.
Did you all choose Friday as the date for jury selection?
Yeah, yes, sir.
All right, and then today was supposed to be for motions. And this was done, I think, back in November. So before I get into your motion for continuance, because I want the record to be clear, this case has been on the court's docket since 2023. We are now in 2025. So May 8th, 2023, this case was set for discovery. It was called back on June 5th, 2023 for discovery. Then it was called back on August 3rd, 2023 for discovery. Then it was called back on October 5th, 2023 for discovery. Then it was recalled on December 7th, 2023 for discovery. Then it was called on January 30th, 2024 for discovery. Then it was set for jury trial, and it did not go to jury trial because there was more discovery. So then we came back on April 2nd, 2024, and it was set for jury trial for October 14th, 2024. Then everybody said, we can't do that. We have vacation, we have this. Then we came back on September 19th. I'm sorry, we were here on April 2nd, 2024. Then we came back on August 27th, 2024. Then it was recalled for September 19th, 2024. Then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then we had the jury trial scheduled for October 14th, 2024. Then we came back on November 21st, 2024, discovery acknowledgement sign. And then we came back on December 2nd, 2024. I told both parties I wouldn't charge a continuance to either side. Then we came back and here we are. So I'd like the record to be clear on what is happening in the case. So now I'll hear your motion for continuance.
Yes, Your Honor. With respect to the court's recitation of the history, I think it's important that we make clear the settings that were held in September of 2024, we had every reason to believe when they were being discussed in the spring of 2024 would hold based upon the production that the defense had already received and based upon the state's representation that apart from jail correspondence, which was of little evidentiary value in the case, no additional discovery would be forthcoming. In July of 2024, the defense, in getting ready for that trial setting and making preparations, found a one-line entry on one page of what is otherwise a very extensive and copious amount of paper discovery, referencing a remark by a detective that he wished that he could also have in his possession ballistics reports done on a firearm that was recovered from Jalen Bell, who is an indicted co-defendant in the case, who has already pleaded guilty and been sentenced to prison. We, based on the discovery, came to the conclusion that no such firearm had ever been tested and that its origin, or its location at that given moment was unknown. We began conferring with Jason Garahan for the state about this matter, and we tried to bring this matter to the court's attention. Mr. Garahan engaged.
Wait a minute, let me stop you right there. What do you mean you tried to bring it to the court's attention?
We informally approached the court, I believe, on a couple of different occasions to advise that this was a matter of concern, and then eventually we filed
Are you talking about
motions.
when you filed the motion for continuance?
The original motion for continuance was not the first time that we had made the court aware of the issue, is what I'm trying to divert to. We were concerned almost immediately in late July, early August of 2024 that this was going to be a matter of concern, and we were trying to get to the bottom of what was going on.
But you all picked the court date
Well, Your Honor,
for the jury trial.
yes, and as I'm explaining, that court date was selected sometime long ago. In the course of preparation for that, we found a very, very, very small reference to this firearm in what is otherwise a very, very large amount of evidence. We advised the prosecution of that fact and sent over a draft motion to compel about anything that was related to it. But of course, we didn't need to file or urge the motion to compel because Mr. Garahan, who has been doing an excellent job keeping up with this, was similarly, I believe, and correct me if I'm wrong, not really aware of the firearm recovered from Jalen Bell because previously it had had such little significance.
So you didn't file a motion with the court urging the court to compel any evidence, correct?
We approached the court and advised the court of the fact that we were trying to sort out this discovery matter between the parties, which we did. We sent a draft motion to compel over to the prosecutor, and rather than having to urge it formally to get an order for the production, the prosecutor undertook his own independent steps to locate that firearm.
All right, so I'm just trying to get the record to be clear, because I like for the record to be clear.
I'm doing my
Nothing was urged with the court. No motions were given to the court about any other evidence, correct?
Well, in September, Your Honor, I believe we did urge a reset or a continuance based upon this information. But I'm just giving the backstory to the time when we formally discussed resetting the case because of it was not the first time that we had brought it to the court's attention that we were concerned it might cause delays in the process. And I'm further just trying to explain that this wasn't evidence that the prosecutor just had in hand and it was in his file and he just hadn't given it to us. It was information that Mr. Garahan similarly did not have anything more than we did about it at the time that we corresponded. Now, law enforcement involved in the case may have, but it hadn't made its way over to the DA's office with the rest of the discovery.
So that's September, October, November, December,
I'm not quite-
January?
I'm not quite done with the recitation, Your Honor. I do want the record to be clear.
Sure.
So we advised Mr. Garahan of this throughout August and September. Efforts were made to locate this. The prosecutor advised that they had identified the firearm that we were discussing, and they sent it over for ballistics testing. That ballistics testing came at the end of September in accordance with when the court reset this matter for this issue. We engaged an expert witness, Ed Huskey, to conduct his own independent analysis of the firearm. Mr. Huskey advised he would not need a laboratory of his own to conduct that analysis, that he could work off of the bench notes from the firearms investigator for the state of Texas. My records indicate that we engaged Mr. Huskey formally on the 10th of October, but we would have been in discussions with him the week prior. We have sent Mr. Huskey, we believe, everything that he needs to complete his analysis, but Mr. Huskey has advised that he has not finished his analysis. This was the major pressing concern of the remaining settings of the fall, is that we did not have the ballistics analysis. And we believe that this is an extremely material piece of evidence because it goes to the heart of the state's case, which is that Mr. McIntyre was the shooter in this engagement, and that there are at least, there are 4 other individuals in the car besides the deceased. So, and the deceased, just to give a brief summary of the facts, the police that have investigated this have averred that the deceased was ejected from the vehicle or forced out of the vehicle, that he jumped back onto the hood of the vehicle, and that they allege Mr. McIntyre discharged a firearm and killed him. So if, in fact, that firearm that was in the possession of Jalen Bell were to be identified as the firearm, or if it could not be ruled out as the firearm, that would be a material aspect of Mr. McIntyre's defense, and an essential one. So that explains the general landscape. Yes, along the way, there were discussions about scheduling conflicts, some of them of a personal nature with some of the litigants. But the primary thrust and reason why we have been resetting this matter time and again since September has been out of concern for the fact that the defense has been unable to independently.
No, this has been reset since May of 2023.
Yes, Your Honor. And I'm just explaining, we did not discover this information until the time frame that I am letting the court know about. We discovered it at the end of July. Throughout the course of August, we were conferring with the prosecution. In September, we had discussions at the bench about this matter on the record, in which it was established that we needed this information, that it was material. The court granted the continuance on that basis. The state was able to produce for us a ballistics report for this firearm. That ballistics report required us to have to go and independently vet whether the report was accurate, or if there were any reasons that we might be able to cross-examine the author of the report based upon his analysis. And that's what we have been working very diligently to try and accomplish, but we don't have that report yet. In the interim period, at this court's last setting in December, the court asked if discovery had otherwise been fully complied with, and we believe it had, apart from this continuing issue that we've experienced regarding Mr. McIntyre's jail correspondence, which we've now discovered the reason why we've been unable to download that material is because an associate in Mr. Goldstein's office, who's only made one filing in the entire case, has mistakenly been placed on the clerk's list as the lead counsel. And as a result of that, neither I nor Mr. Goldstein were able to access from our credentials that e-discovery. However, Mr. Garahan has been extremely helpful with us because the state didn't realize why we weren't getting the discovery either until just a couple of weeks ago. And we have been going over and meticulously getting this information on external hard drives and hand it over to us so that we can process it. It's voluminous, but it is largely not relevant to the litigation. At that setting, the court asked of the state of Texas whether or not it had fully complied with Article 3914, and both parties represented that we believe that it had. Since that time period and since the first of this year, and we've
Just 1 second, let me go back to this expert. According to our last hearing on October 10th, 2024, the information I received from both parties was this. I said neither side would be charged with a continuance. State was unable to have some witnesses appear because of the county budget. You requested a testing of the weapon. So everybody knew about this weapon. And I said that both parties have been diligent on doing this. And then the defense was to file a motion to allow for testing of the weapon, which I'm assuming you did and the court signed.
We didn't need to, Your Honor,
Yeah,
because
well,
our
well, just-
expert advised he didn't need it.
And then it says defense expert has no lab, will seek outside lab or state lab for testing. So you all had this information, unless there's a different gun, everybody had this information from October 10th.
That's what I'm explaining, is that by October 10th, I mean, so we discovered there was a problem in end of July, beginning of August. Throughout August, we were looking for a gun. By the September settings, we were aware that there was a gun.
Yes.
And then the state produced a report. On the 10th was the date that we had engaged formally Mr. Huskey, having conferred with him informally for a week prior. We weren't even sure if we would be designating him as an expert at that time. We, at the time that we had that bench conference, assumed, not being firearms experts ourselves, that it would require Mr. Huskey to have access to the physical weapon and to the laboratory analysis. Mr. Huskey has advised us, and I believe that this is consistent with what I've later learned talking to other people in the field, that it is very common in the industry of firearms and tool mark examination for the examiner to be able to run a preliminary round of review and critique of the methodology and the reliability of the data based solely on the bench notes and the work product of the original firearms investigator, and that we would not need access to a laboratory. That led me to have an overinflated sense of how quickly we might be able to get it done if it was simply a matter of paper review. But it has turned out that that doesn't seem to be the case, and Mr. Huskey has not, as of today's date, given me a final report that I would be able to make use of. In fact, I'm having to essentially designate him somewhat prematurely because I don't have an opinion upon which I can confidently say that I would choose to
Have you called him to ask him
Multiple
when he's
times.
available?
multiple
Well,
times.
what's the answer?
Well, he's physically available for the trial, but he doesn't have any
When will he
analysis.
have analysis done?
He hasn't given me a straight answer.
Well, you need to call him and ask, because this case is not going to be sitting out here forever. And this is the court's problem. My problem is everybody comes in here and wants a special setting for trial. I give you a special setting for trial, and then at the last minute, the week before trial, people are not ready. People want 200 jurors brought down, and then all of a sudden, we need a continuance. So we're going to stop this hearing. We're going to go in recess on this hearing. You're going to call him, and you're going to find out when he's going to have it done.
Yes, Your Honor. But before we stop the hearing,
No, we're going to stop it now because you need to call him and find out when it's going to be done. Because I need to know if he's going to have it done in 2 years or 3 years. We will pick this up where you left off, but that's the number one question for the court. When is it going to be done?
I will report back.
All right, thank you.
Your Honor, may I be heard on about one matter?
Yes.
Thank you, Your Honor. Additionally, this past week, we were advised that the state's chief witness has actually testified under oath, and that's what I was trying to address. The Court of Criminal Appeals, in a recent decision from last June, held that the transcript of such a testimony is discoverable as soon as is practicable. We've been asking for this kind of stuff for years.
All right,
And
so this
just-
is what I need though, Attorney Goldstein. I
Yes.
need to know when your expert is saying he's going to be done with this.
I understand, but we also need the transcript of that testimony because the Court of Criminal Appeals has been very clear. We can't be compelled to try the case if a chief witness has given prior sworn testimony
All right,
about
so
the same matter.
I
That's all.
understand what your attorney is saying, Attorney Goldstein, but what I'm telling everyone, I want to know when your expert says he is going to be done with his analysis. So that's what I need to know right now.
Thank you, Your Honor. We'll get on that. Be right back with you on the record in just a moment.
All right, thank you. Back on the record in 2019, CR 12495, State versus Tamar McIntyre. Could I have parties re-announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
John Hunter and Jerry Goldstein for Mr. McIntyre.
Good morning, Your Honor.
Good morning.
Your Honor, per the court's request, I have called Mr. Huskey to ask him when he might have a report for us, and he advised that he should have a report ready for us in 30 days.
All right, the good old 30 days. All right, and let me do this because the record really was unclear as far as the court's rendition of the timeline, because the document that I was looking at was not the murder case. It was on the docket sheet was from the
Controlled substance case.
yes, the controlled substance. So let me read into the record the times that this case has been in this court. And actually, this case started in 2019. So December 19th, 2019, there was a pretrial hearing. That hearing, we came back on March 3rd, we came back on April 27th, 2020. Then we came back on March 3rd, 2021.
Your Honor, I'm so sorry to interrupt, but I want to make sure that the court has the timeline accurate because there's a couple of problems. The first being that this case was originally filed as a juvenile matter.
Mhm.
Because Mr. McIntyre was certified an adult in Fort Worth, that became a foregone.
Yeah, I understand that. So I'm reading what's on this document, just reading it into the record. So December 19th, 2019, there was a pretrial and it came back on March 3rd, 2021. Then it was recalled for April 21st, 2021. Then it came back on June 17th, 2021. Then it came back on August 10th, 2021. Then it came back on January 13th, 2022. Then it came back on October 26th, 2022. Then it came back on December 6th, 2022. Then it to this court. And when it came to this court, it came on May 8th, 2023. And then it was retained attorney. And it came back on June 5th, 2023. Then there's discovery on August 3rd, 2023. Then there's discovery hearing on October 6th, 2023. Then there was discovery hearing on December 7th, 2023. Then it was recalled for January 30th, 2024. Then it came back on February 22nd, 2024. Then it came back on March 11th, 2024. Then it came back on April 2nd, 2024. It was set for jury trial in the central jury room on October 11th, 2024. And I bring that setting up because that is a special call for jurors. And the jurors are paid, I believe, approximately $75 per juror. And both, well, I won't say both, but there was a request for 200 jurors to be brought up on that day. And testimony was to begin on October 14th. That did not happen. So we came back on August 27th. Then it was recalled for September 19th, 2024. And then it was recalled for September 23rd, 2024. Then it was recalled for October 10th, 2024. Then it was recalled for November 14th, 2024. Then it was recalled for November 18th, 2024. Then I'm sorry, just one moment. Strike that last one. It wasn't November 14th. Then it was recalled for November 21st, 2024. And then it was recalled for December 2nd, 2024. And then it was recalled for November 21st, 2024. And that's when all parties chose jury selection, again, in the central jury room for 200 jurors at $75 per juror, which the taxpayers are paying. And we were supposed to be having jury selection on Friday, February 7th. So with regards to your person, you're saying 30 days?
Mr. Huskey advises that he can give us an opinion by 30 days from today's date, Your Honor. Yes.
Mhm.
That's the first major point of concern in our motion for continuance.
Mhm.
The next point point of concern is actually something that I did not learn of until yesterday evening.
Mhm.
When the co-defendant was pled way back, like in 2017 or 18, it was my understanding that there was a sealed plea agreement that was entered into for that. The state has disclosed the contents of that agreement, and that's not the issue. What I learned of last night is that it appears that when the plea was received by Your Honor's predecessor on this bench, the prosecution put the co-defendant on the witness stand and elicited substantive evidentiary testimony from the witness about Mr. McIntyre's involvement in this shooting as a condition of the plea agreement, or as, I guess, sort of a memorialization of the testimony that she had promised to give pursuant to the plea agreement. We have not received any such transcript, and I never thought to examine that because, as the court's well aware, a substantive testimonial rendition of the factual basis of the plea is very seldom entered into in state court in Texas. And so it was of no value to us to pull a colloquy of, is this a voluntary plea agreement, or those kinds of things. But it appears that there is substantive testimony of the witness that has not been produced. I advised Mr. Garahan of that issue this morning, and he is similarly unaware of such a transcript, but it is something that we would absolutely need and we have a right to under 3914.
And by the way, Your Honor, the motion under 3914 and the letters that are a matter of record requested any such statements back some 3 or 4 years ago. Anyway.
So that's another major point of concern. In addition to that point of concern, since the new year, since January, and since it was last represented to the court that the discovery process had completed itself, the state has turned over a large quantity of additional material, which I've outlined by bullet point in our sworn motion for continuance, some of which is unimportant, but some of which is substantively significant, including statements from indicted and convicted co-defendants, none of which I've had an opportunity to review because I've been defending another murder case up until last Friday. Additionally to that, when I first informally approached Your Honor back on the 24th of January to advise the court of this concern, I was advised by the prosecution that there has been a reworking of an old phone dump that previously didn't have a whole lot of substantive value to the case that needed to be turned over and was turned over. We've received a flash drive or an external hard drive with the contents of that phone. This is a phone that was recovered from the Kia, which is the vehicle where this incident is alleged to have taken place.
All right, so this is what appears to the court. It appears to the court that this is one of those cases because obviously people are not reading things, that this needs to be brought back every day for you all to decide if you all have discovery. And I will tell you this, I'll grant your motion for continuance. Jury selection will not take place in the jury room. There will not be 200 jurors called up. You're going to be in this courtroom, and it's going to be, I think, Deputy Laura, how many jurors fit in this courtroom? It will be 75 jurors. That's what's going to happen. There will be no other special settings. Do not ask for a special setting. Do not come to the court saying the room is too tight, because this is what you're dealing with, because this will be the second continuance where 75 jurors were called up. And 200 jurors were called up and they're paid $75 a juror. That's the taxpayers that pay that. And then people, I believe you came and said, well, can't we just use those jurors for other courts? No, because nobody calls up jurors on Friday. Those jurors are called up and they're paid. And they're paid for Friday. So do not come back to this court asking for the central jury room. That will not be done. The end on that subject matter. With regards to this witness who testified, this co-defendant, state, do you know who the co-defendant is?
My understanding is, I did speak with Mr. Hunter off the record, Your Honor, and I was just brought to my attention that allegedly that this individual, and I do know the individual that is named, that he gave me the name, apparently got on the stand through what Mr. Hunter mentioned to me and was questioned by the judge at the time, I believe Joey Contreras, and also the prosecutor, Jason Goss. I know that she had defense counsel with her. I don't know if there was questioning through that individual. So I just became aware of that literally probably about 10 minutes ago. We'll do our due diligence to look into that. But again, I just became aware of that through defense counsel just about 10 minutes ago.
All right, well, you all need to find the court reporter, whoever that court reporter was, and you all can get the transcripts from them. I'm only giving you 30 days. It shouldn't take that long to get the transcript. If it was a sentencing, then usually those are 2 pages of testimony. Anything else?
I believe it was actually at the plea, and we have no idea how long it went. I've never seen this in a state court before, but it is fairly critical. And what my hope is that the state already has this, but this is precisely the type of issue that arose in the Heath case that I mentioned from back in June.
All right,
And
so
what I'd like to do is make sure that we at least
counsel,
know.
I'm already giving you your motion for continuance.
No, I know. And I don't want to beat a dead horse. And by the
I
way,
mean, that horse is glued.
well, I understand, Your Honor. And by the way, if it's important to you and Richard, I was in Pamplona for San Fermin back in 1965, and it is an exciting time. But in those days, they didn't have the actual bowls that went into the ring. They had older ones that people, even like little Jewish boys like me, could outrun. That's not true anymore. I would say that my hope is, and what we'll need to do is the state obviously has access to this information, and they've been very cooperative. I just want to make sure that we do get that transcript and we get it
Here's the thing. I'm giving you all this specific time, and this is the only specific time you're receiving. So today, you all need to find out who that court reporter is and ask them for that record. And since it is I know that some attorneys may go on and on. They get paid by the word with Charles Dickens. So I don't know what happened during that sentencing.
It was a plea, Your Honor.
Yes. All right. So that shouldn't take that long unless the attorneys who were on it decided to get paid by the word.
No, Your Honor, the only thing that we've laid out that I anticipate could take long is the production of this phone dump, because.
No, I'm only giving you all 30 days. That's all you're receiving.
Yes, Your Honor. And so to that end, know that we're going to work diligently to process everything that's been produced in that phone dump. But a cell phone dump is typically, terabytes of data.
I'm only giving you all 30 days because let me just tell you, I don't know if you all remember, but this case has been on the docket since 2019. And if you want to say that's juvenile, fine. But it has been in this court since 2023. A phone dump does not take 2 years for people to go through unless they're doing other things, which I understand. Defense attorneys, I understand.
No, Your Honor, you don't understand. We got it on the 24th of January, 2025. That's what I'm saying.
We just got it, Your Honor.
And so the problem
Well, I
we
have
face is.
This is what I don't know. I want to know why you just receiving it then. That's my question.
That's-
But everybody agreed that everybody had everything.
That's the point.
Just to address the phone dump, it is a phone dump that was given previously. It is just that the certain things that were on our end on Veripic, I don't know how eDiscovery, obviously I don't know if they have access to eDiscovery. Was like certain JPEGs or something more being able to be opened because of however it got transferred. So that it is the original dump of that phone. It's just that certain pictures and stuff weren't able to be opened.
Now we can use it, understand it, and hear it and see it. And we weren't able to do that in the form that it was previously given, Your Honor. And may I ask a personal issue on the date of a month? Can we start on Monday the 10th, Your Honor? I'm in federal court the week before that.
All right, Norma, will you set this the first week in April? This is going to trial.
April.
Yes.
Your Honor, I just want to clarify that something for the purposes of the record on this discussion about the phone dump. the defense's position as to the previous version of the phone dump was that because it didn't have a whole lot of recoverable information on it, and there were lots of images that were not available for use, the state couldn't make use of it any more than the defense could, and that may be to our advantage. So we have to now go through this material for the first time that was not accessible in the original dump. I'm letting the court know this, understanding the court's ruling, and understanding the court's urgency to get the matter tried, because obviously we are going to have to document our due diligence and our efforts with respect to it, and we will update the court as that progresses. But I also want the court to keep in mind, as Mr. Goldstein mentioned earlier on some of these other matters, that one of the remedies the court could entertain is an exclusion of that evidence as being untimely.
This is what we're gonna do. Motion for continuance is granted. Norma, set this, since you're taking a while, set this for jury selection is gonna take place on March 31st. No problem. March 31st, jury selection.
I'm sorry, is that a Friday or is that a Monday?
That is a Monday.
And then can I be assumed that it would then testimony start the next day?
Yes. There will be no further continuances without good cause.
Thank you for your consideration and your patience.
You're welcome. All right, anything else?
Not from the state, Your Honor.
Not from the defense.
Thank you.
May I just inquire, is it my understanding that that Joanna's plea transcript, that we don't know if there is one? I mean, we know that she testified. Is the state aware that a transcript has been made?
The
I
state,
have no idea.
the state, no, Mr. Goldstein, my understanding is I got all my information from Mr. Hunter. So
Thank you.
I have no knowledge of whether a transcript has already been prepared. I gather based on the circumstances, it has not, and we're going to have to find the reporter and request the transcript to be generated.
Thank you.
Is there anything else?
nothing from the state.
Nothing
Thank
from the
you.
defense.
Thank you, Your Honor.
You're welcome.
May we be.
As this hearing comes to a close, one thing is clear. Today wasn't about deciding whether Tamar McIntyre is guilty or innocent. Instead, it was about making sure the trial moves forward with all the necessary evidence available to both sides. Throughout the hearing, the judge repeatedly emphasized that this case has been pending for years and that the court cannot continue postponing trials indefinitely. At the same time, the defense argued that newly discovered evidence, pending ballistics analysis, additional digital evidence, and potentially crucial prior sworn testimony could directly affect the fairness of the upcoming trial. Ultimately, the judge granted one final continuance, but drew a firm line in the sand. The expert report must be completed within 30 days, the missing transcript must be located, and both sides must be fully prepared because there will be no more unnecessary delays without good cause. It's a reminder that the justice system must balance two equally important principles: protecting a defendant's right to a fair trial while also ensuring that justice is not delayed forever. Now, we'd love to hear from you. Do you think the judge made the right decision by granting one final continuance, or should this case have proceeded to trial immediately? Share your thoughts in the comments below. And if you found this courtroom breakdown informative and engaging, make sure to hit the like button, subscribe to the channel, and share this video with others who enjoy real courtroom analysis. Thanks for watching, and we'll see you in the next courtroom breakdown.